The bailiff read the case list in a monotone, and my sister stood before the last word landed, not to honor my grandfather, but to claim him. She wore a tailored cream coat over black, a quiet luxury that suggested authority before she spoke. Her hair was precise, her expression controlled, and when she looked at me, it was calculation, not grief. Her attorney, in a sharp suit with a soft voice and expensive watch, walked to the counsel table carrying a thin stack of papers. He slid them forward like a weapon. "Your Honor," he said, "we request immediate transfer of the estate to my client effective today." My parents nodded in unison, as if rehearsed. My mother's hands were folded solemnly. My father stared ahead, jaw set, treating this as a business matter with me as the obstacle. The judge looked at me first. "Miss Vale," he said flatly, "do you object?" My sister's lips twitched, eager to hear me refuse. I didn't. I straightened, placed my hands on the table, and spoke steadily. "Yes," I said, "I object." Her attorney smiled faintly. "On what grounds?" he asked, confident he would win. "I haven't given one yet," I replied. "I want to wait until the last person arrives." The judge blinked. "The last person?" he repeated. I nodded. "Yes, Your Honor." My sister laughed softly, dismissive. "This is ridiculous. There is no one else." My father glanced at me briefly, a look I remembered from my teenage years when he wanted to shame me. "You always do this," he muttered. The judge leaned back, adjusting his glasses. "Miss Vale, this is probate court, not a stage. If you object, it must be legal." "It is legal," I said calmly, "but it isn't mine to explain." Her attorney stepped closer. "Your Honor," he said smoothly, "we request emergency appointment because Miss Vale has been uncooperative. There are assets that need protection, and my client is the responsible party." That word, responsible, was always a weapon in my family. "Give us control and stop asking questions." My mother sighed softly. "She's grieving," she said. "She doesn't understand how these things work." My sister's eyes stayed on me, cold and bright. "I'm just trying to prevent mistakes. Your grandfather would want this handled properly." I thought about how quickly she found a lawyer, how fast the petition appeared, how rehearsed my parents looked behind her. The judge turned a page. "This petition requests full authority over the estate," he said. "It alleges the respondent is unfit and may interfere." "Correct," her attorney confirmed. "And you're asking me to grant that today?" the judge asked. "Yes, Your Honor," he replied. "Effective immediately?" The judge looked at me. "Miss Vale, what is your objection?" I remained still. "They are asking you to act without the full record," I said. My sister laughed sharply. "There is no hidden record. He's dead. This is what happens." The judge's patience thinned. "Miss Vale," he said to my sister, "you will not speak out of turn." My father's lips pressed tighter. My mother's eyes narrowed. Her attorney tried to regain composure. "Your Honor, if Miss Vale wants to delay, we object. The estate cannot wait." I looked only at the judge. "It won't be a delay," I said. "Just minutes." The judge exhaled and glanced toward the courtroom doors. "Who are we waiting for?" he asked. "The person who actually controls the inheritance," I said. My sister tensed. "That's me," she said automatically, then corrected herself as the judge looked her way. "If this is a tactic," the judge said, leaning forward. "It isn't," I replied. "I'm asking you to let the record arrive before signing anything." A moment of silence. Then the courtroom doors opened smoothly. A man entered, wearing a plain black suit, carrying an envelope, expression neutral. He walked to the clerk's desk without looking at anyone, held up the envelope, and spoke clearly. "Miss Vale?" The judge blinked, reached for his glasses, and stared at the envelope as if it didn't belong in his courtroom. The man in the black suit didn't raise his voice or explain himself. He placed the envelope on the clerk's desk and said, "This is for the court from the trustee." The judge took it, read the sender line, and whispered, "That can't be." He didn't handle it like routine mail. He held it carefully, turned it over, examined the return address, and then tore it open cleanly. The courtroom was silent. I could hear my sister's attorney shift. The judge pulled out a single folded document first. Thick paper, embossed seal, formal signature block. He scanned the top line, jaw tightening, then read aloud, "Hawthorne National Bank Trust Department." My sister's expression flickered for a moment before she regained composure. Her life had revolved around controlling money, yet hearing a bank named in court left her looking caught, not powerful. The judge continued, "This is a notice of trust administration," he said. It states the decedent's assets were placed into a revocable trust, which became irrevocable at death. My sister's attorney stood. Your Honor, we are in probate. The judge didn't look up. Sit down, he said, turning the page. This, he added flatly, is a certification of trust identifying the trustee. He paused, then read, Successor Trustee, Hawthorne National Bank Trust Department. My parents stiffened. They had aimed for control. A bank doesn't operate like a family. It follows documents, conditions, and risk. Her attorney tried to recover. Your Honor, even if there is a trust, probate still has jurisdiction. The judge looked up. Counsel, your motion requested all inheritance effective immediately. He tapped the paper. This certification shows the probate estate is minimal. Most assets are held in trust. He instructed the clerk, mark this as received. Then he looked at my sister, not as family, but as a petitioner attempting to take what she didn't control. Miss Vale, he asked her, did you know your grandfather established a trust with a corporate trustee? She lifted her chin. He was influenced. He didn't understand what he was signing. The judge didn't argue with her feelings. He held up the next page. This notice includes the trust's execution affidavit, a list of witnesses, and attorney certification that the decedent signed with full capacity. My father's mouth tightened. My mother's eyes narrowed. Then the judge read slowly, emphasizing each word. No contest clause triggered. Any beneficiary petitioning to seize trust assets, contrary to the terms, forfeits their distribution. Her attorney's face drained. My sister's eyes widened briefly, then narrowed, as if trying to intimidate the paper. My mother unclasped her hands. The judge addressed her attorney. You filed a motion for immediate transfer of all inheritance to your client? Yes, Your Honor, the attorney said carefully. You understand this clause is enforceable. Filing your motion may already have caused forfeiture. The attorney swallowed. Your Honor, we dispute the validity. You can dispute it, the judge cut in, but you cannot pretend it isn't there. He turned to me. Miss Vale, you asked to wait for the last person. Was this the person? Yes, I said, keeping my voice level despite my pulse racing. The trust department is the trustee. They control distribution. The man in the black suit spoke for the first time. Calm and precise, he addressed the judge. Your Honor, I am not here to argue. I deliver notice and confirm the trustee's position. The trustee does not recognize the petitioner's request. Assets will be administered per the trust terms, and we request the court dismiss any attempt to seize trust-controlled assets through probate. My sister snapped. You can't just... The judge raised his hand. Miss Vale, you will not speak out of turn. She fell silent, her breathing faster and thinner. Her attorney stood again, attempting to recover. Your Honor, at minimum, we move to compel production of the full trust. We question whether my client was improperly removed or if there is undue influence by the respondent. The judge's eyes didn't soften. Undue influence is a serious allegation, the judge said, and you just watched audio evidence of attempted coercion directed at the decedent, which did not come from the respondent. My father's jaw ticked. The judge turned to the man in black. Has the trustee provided the trust instrument to counsel? Yes, the man replied. A complete copy was delivered to both sides yesterday via certified service. My mother's head snapped toward my sister's attorney. They had known, or should have known, yet filed anyway. The judge let that fact linger, then looked at my sister. Miss Vale, did you receive the trust documents yesterday? Her lips parted. For the first time, she appeared less like an executive and more like someone cornered. She began, but her attorney cut in. Your Honor, we received a packet. The judge interrupted. Counsel, if you received a packet containing a no contest clause and still filed a motion demanding full inheritance immediately, I want you to understand how that looks to this court. The attorney went still. The judge turned to the clerk. Set a hearing on standing and sanctions and enter the trustee's letter into the record. Then he looked directly at my sister. Miss Vale, if you are a named beneficiary, triggering forfeiture today may have cost you more than you intended. Her face tightened. Her eyes cut to me, not about money, but because the institution she trusted had just marked her as a risk. She tried a new approach. Your Honor, she said loudly, with practiced urgency, I need to put something on the record. The judge's eyes narrowed. What? She turned to me. The one word my parents had been saving, elder abuse. The judge's expression shifted, not because he believed her, but because the court now had to assess whether she had proof or was making a false allegation. Elder abuse, she repeated, louder. My mother softened into performance grief. My father leaned back, eyes narrowing, as if this was their planned move. Her attorney stood beside her like an emergency exit. Your Honor, we request an immediate inquiry. The respondent isolated the decedent, controlled access, and coerced him into signing documents benefiting her. The judge leaned forward. Counsel, those are serious allegations. What evidence do you have today? My sister didn't blink. Witnesses, she said, gesturing. Two relatives stood awkwardly near the back. My mother nodded subtly at them. The judge remained unimpressed. Witnesses can testify, he said, but I want concrete evidence. Medical reports, prior complaints, police records, PS involvement, anything. My sister's jaw tightened. He didn't want to embarrass the family, she said quickly. He was scared. The judge stayed flat. Then explain why he called emergency services himself. Silence. She tried again. He was confused. He didn't know what he was doing. The judge glanced at the bank's envelope. This trust was executed with a capacity affidavit and witnesses. That is not confusion. That is formalized intent. My father's attorney rose. Your Honor, we also have evidence the respondent had account access and controlled communications. Elliot immediately objected. Objection. Argument without foundation. The judge held up a hand. Counsel, do you have that evidence here? His attorney hesitated, then said, we would request discovery. The judge's eyes hardened. Discovery is not a fishing license. You do not accuse someone of elder abuse in open court as a strategy to seize trust assets. My sister's face flushed. It's not a strategy, she snapped. The judge leaned back. Then bring evidence, not theatrical relatives. My mother's voice trembled. Your Honor, she kept us away. She made him hate us. The judge looked at her once. Ma'am, this is not family therapy. Then he turned to the one person in the room with no emotional stake, only fiduciary responsibility. The judge addressed the man in black. Sir, does the trustee have any documentation of concerns regarding undue influence or abuse? No, Your Honor, he replied. The trustee conducted standard intake. The decedent met privately with counsel, confirmed his intent, and provided a letter of instruction with supporting materials. The judge's gaze sharpened. Supporting materials? Yes, the man said. A log and a statement the decedent wanted preserved. My sister's head snapped up. What statement? She demanded. The judge didn't look at her. Provide it, he said. The man retrieved a second, thinner, unmarked envelope and handed it to the clerk, who passed it to the judge. He opened it and pulled out a single-page letter, reading silently with careful attention. Then he looked at me, not warmly, but with the weight of understanding. Miss Vale, he said, did you know your grandfather prepared a written statement anticipating today's allegations? Yes, I said quietly. He told me he did, but I didn't know what he wrote. My sister's breathing changed. Her nails dug into the counsel table. The judge scanned the top of the letter, then read aloud. If you are reading this in court, it means my son and his family tried to take my estate by accusing my granddaughter. My mother made a sharp sound. My father's face went rigid. My sister's attorney sat down slowly, realizing the precarious position. The judge continued, reading selectively to make the record undeniable. My grandfather had asked me to move in after his fall. He had met with counsel alone. He created the trust fearing pressure tactics and rapid signature demands. Then he reached the line that seemed to make him pause, reading aloud. On the night I called emergency services, my son brought a mobile notary to my home to obtain new signatures. I refused. I asked for witnesses. If they call this elder abuse, they are projecting their own conduct. The courtroom stayed silent. My sister sat very still, eyes flickering as she sought a way to survive the record. My father's attorney rose cautiously. Your Honor, we object to hearsay. The judge cut him off. It's a statement of intent from the decedent, offered to show his state of mind consistent with the dispatch audio. He held the letter slightly aloft. This court will not entertain a last-minute elder abuse allegation used to seize assets held by a corporate trustee, he said. If you want to file a petition with evidence, you may do so, but not today, not like this. My sister's attorney swallowed. Your Honor, we'd like to withdraw the motion. The judge's gaze stayed cold. You cannot withdraw consequences, but you can stop digging. He turned to the clerk. Dismiss the motion and set an order to show cause hearing regarding sanctions for the filing and false assertions today. My mother went pale. My father's jaw clenched. My sister's mask cracked. So she gets everything, she snapped. The judge did not flinch. The trust will be administered per its terms. Ms. Vale's petition to seize all inheritance immediately is denied. My sister's hands shook as the man in black spoke again, calm and precise. The trustee will suspend distributions to parties who triggered the no contest clause until further review. We will follow the trust language exactly. My sister hissed. Suspend? That is, he said simply. The judge leaned forward. Miss Vale, you walked into this courtroom acting as if it were already yours. Now you leave with nothing decided in your favor today, and you will answer for the way you tried to obtain it. Her eyes turned to me, full of hatred and humiliation. She whispered, barely audible, "This isn't over." At that moment, the bailiff stepped in quietly and spoke to the judge. The judge's expression shifted slightly. He nodded once, then looked directly at my father. "Mr. Vale," he said, "remain seated." My father froze. "Why?" "Because," the judge said flatly, "I've just been informed there's a deputy in the hallway with paperwork for you, and it isn't from this court." The courtroom doors opened. A uniformed deputy walked in holding a document with a bold header. My father's face turned gray as the deputy said, "Sir, you've been served." My father didn't stand or demand respect. He just stared at the deputy, as if the badge had suddenly outweighed his wealth. "What is this?" he asked, voice tight. I hope the deputy didn't play games. "Service of process," the deputy said. "You can accept it here or in the hallway." My father's attorney whispered something urgently. My father ignored him, snatched the papers, and flipped the first page with shaking fingers. His eyes scanned the header, then froze. This wasn't probate. This was criminal. The judge watched him, expression flat. "Mr. Vale, this court has nothing to do with that paperwork, but you remain under oath from earlier testimony." My father swallowed. "Your Honor, this is harassment. My family is being targeted because my daughter—" "Stop," the judge cut him off. "Your daughter is not the one who called emergency services to report a coercion attempt. Your daughter is not the one who filed a false motion in this court. Your daughter is not the one who attempted to seize trust assets held by a corporate fiduciary." My mother's mouth tightened. "We were trying to protect the family," she whispered. The judge didn't soften. "Then you protected it into a referral," he said. The deputy shifted slightly. 2 more uniformed officers stood near the doors, quiet, just present in the way law enforcement does when anticipating escalation. My sister's attorney cleared his throat. "Your Honor, we request a brief recess to confer with our clients." The judge looked exhausted by the suggestion. "You can confer, but this motion is dismissed. The trustee will administer the trust, and I will see counsel back for the order to show cause hearing." He picked up his pen, turned away, then stopped. "One more thing," he said. He addressed the man in black. "Sir, does the trustee request any protective order?" "Yes, Your Honor," the man replied. "Given the attempted interference, the trustee requests an order prohibiting the petitioners from contacting financial institutions, custodians, or third parties to access trust assets, and prohibiting harassment of the primary beneficiary." My sister's head snapped up. "Harassment?" she scoffed. The judge's eyes moved to her. "Miss Vale, you just accused someone of elder abuse with no evidence in open court. You are not in a position to scoff." He looked back at the trustee's representative. "Granted. Draft it. I'll sign today." My mother's face drained. "You can't keep us from our own daughter," she whispered. "You can keep yourselves from committing misconduct," the judge replied flatly. Elliot leaned toward me. "This is the cleanest order we could have hoped for." I nodded, but my eyes stayed on my parents. My father held the criminal paperwork, and I could see calculation shifting behind his eyes. Not remorse, just damage control. The judge adjourned. "Court is recessed," he said. When the gavel hit, my mother moved toward me, close enough to change the air. "You did this," she hissed. "I didn't," I said quietly. "He ruined himself." My sister whispered, voice tight, eyes wild. "You're going to lose everything. I'll make sure you do." "You already tried," I said calmly. "And the trustee didn't even have to raise its voice." Her face twisted. "You think you're safe because a bank sent a suit?" She spat. "I'm safe because Grandpa planned," I said, leaning slightly close enough for her to hear. And because you can't bully a record. Her lips parted, then she did something colder, turned her phone face down, as if sending something she didn't want anyone to see. Elliot noticed. Don't engage, he murmured. We're leaving. We exited through the side door. Outside, the courthouse air was sharp and indifferent to family drama. At the curb, Elliot stopped, looking me in the eyes. Here's the concrete ending you wanted. The trust controls everything. The petition is dismissed. The no contest clause is triggered and will be enforced. Your parents don't get access, and the court signed an order preventing interference. I nodded. And your sister? Elliot's mouth tightened. If she's a named beneficiary, she likely forfeited today. That's what her lawyer is realizing right now. We stood for a moment, breathing. Then Elliot's phone buzzed. He checked it, expression changing like it had before. What? I asked. He held up the screen. A notification, official, short. Hawthorne National Bank Trust Department. Security alert, attempted access blocked. My stomach went cold. The hearing was over, the order signed, and someone was still trying to touch the assets. Elliot's voice was quiet. They're doing it right now, he said. I stared at the alert. In that moment, I realized my sister hadn't turned her phone face down to contain frustration. She had done it to act. Elliot didn't hesitate. He called the trust department while we were still at the curb, the courthouse behind us, my parents somewhere inside pretending nothing had happened. Hawthorne Trust, a woman answered, her tone calm and steady. This line is recorded. How may I help you? This is Elliot Lane, he said. Counsel for Maureen Vial. I just received a security alert. Attempted access blocked. I need details. After a pause, she spoke clearly. Not panic. Procedure. Yes, Elliot said. What happened? An attempted login to the beneficiary portal failed multi-factor authentication. Immediately afterward, there was an attempt to change the contact phone number on file. My mouth went dry. Change it to whose? The officer didn't answer me directly. She asked Elliot, Are you authorizing me to disclose the attempted change request data to your client? Yes, he replied instantly. She continued. The attempted phone number change came from a device associated with the petitioner, Alyssa Vale. I closed my eyes for a moment, picturing her flipping the phone face down in court, not hiding shame, but action. Elliot's voice stayed calm. Did she authenticate? No. The system blocked the request. A manual flag was placed. Distribution status is now on hold for fraud review. Good, Elliot said. Freeze all changes. No portal contact changes, no phone, email, or address updates without verified in-person ID. Already done, she replied. A report has been generated. Send it to my office, Elliot said. Note there's an active court order prohibiting interference. Understood, she replied. The trustee has the court order on file and will comply. The call ended. The quiet afterward felt sharp. Elliot looked at me. That alert? It's exactly why corporate trustees exist. They don't get bullied or guilt-tripped. They log and block. I nodded slowly. So she tried and failed? Yes, he replied. And she just created a record that will follow her into sanctions. We drove straight to Elliot's office. Not for drama, but to secure everything. While my family was still processing, Elliot had me sign a single-page instruction. All trust communications routed through counsel, no direct family contact, and any attempted changes treated as fraud. Then he forwarded the bank's security report to the judge's clerk with a note. Attempted access blocked minutes after court recess. No threats, no speeches, just a timestamp. An hour later, Elliot's assistant informed us the trustee rep called back. On a video call appeared the man in black, calm, plain suit, like a uniform. Miss Vale, he said, I want to make something clear. I didn't speak before. I let him. The trust will distribute only according to its terms. No exceptions due to family pressure. No temporary transfers, no advances. He glanced at a note, then back. Due to today's petition and the attempted portal interference, the trustee has determined that Alyssa triggered the no contest clause. Her distribution is now forfeited, pending court confirmation. My chest tightened. Part relief, part disbelief. Elliot asked, and the parents? The trustee rep remained composed. Grant and Linda Vale's contingent distributions are under review. Given their participation in the petition and coordinated behavior, their involvement is treated as interference. We will file a declaration with the court. That was the moment it felt administratively final. Not emotionally satisfying, but legally settled. 2 weeks later, The court held the sanctions hearing. My sister's attorney avoided eye contact, stood, cleared his throat, and said, "Your Honor, we withdraw all contested claims and apologize to the court." The judge didn't smile. He imposed sanctions for the bad faith filing, ordered my sister to pay part of the attorney's fees, and entered an order acknowledging the trustee's enforcement of the no contest clause. Then he addressed my parents directly. "Your daughter did not take anything," the judge said. "Your father's documents removed control from you, and you responded with manipulation. This court will not participate in that." My mother cried. For the first time, it sounded real. Not grief, but loss of control. My father didn't cry. He just stared at the floor, searching for a loophole. There wasn't one. Within the month, Hawthorne National Bank completed the first formal distribution under the trust terms. The house remained protected by title, and the remaining assets were administered with receipts, confirmations, and a paper trail my family could never rewrite. As for my sister, her wealth didn't protect her from the forfeiture clause she ignored, assuming courts exist to reward confidence. They don't. Courts reward records. The night the final confirmation email arrived, I sat at my kitchen table and opened the folder my grandfather had prepared years before. Not to relive pain, but to remember the lesson. When people try to erase you with a story, you don't fight story with story. You fight story with proof. 3 weeks after the hearing, the court entered the trustee's declaration into the record. Hawthorne locked the trust completely. No changes without in-person verification. My sister's forfeiture was confirmed under the no contest clause. My parents' request for a family settlement was denied, and the sanctions order required them to reimburse legal fees tied to the false filing. Within 30 days, the trustee executed the first distribution exactly as written, and the property remained protected outside probate. No more motions, no more emergencies, just a finalized record. What did you think of the ending? Was it satisfying, or would you have handled it differently? Drop your thoughts in the comments. If you enjoyed this story, leave a like, subscribe, and turn on notifications. See you in the next video.